You're listening to Systemic Error Podcast. The failure was designed.
Alarm bells. The Supreme Court takes up major case at deck last year. Ex-DOJ prosecutor, based on an article by Tom Bogany. The court is not hiding its politics on guns. The source of power, the relevant power, is not in Maryland, where the ban exists, or in the abstract language of the Second Amendment. It sits with the Supreme Court, which decided to take up a case on whether bans on AR-15s and other semi-automatic rifles are constitutional. That choice matters because the court is not passively receiving disputes, it is selecting which fights to intensify and which rules to unsettle. The decision behind the curtain. Joyce Vance's warning points to the real story. The court's recent behavior has not been neutral restraint, but strategic intervention. She notes the court's use of the shadow docket in service of Donald Trump and then flags this gun case as a likely vehicle for another major ruling. The institution is not drifting into controversy. It is manufacturing the conditions for it. The blame is not where the framing wants it. The sophist framing in stories like this is that the court merely agreed to hear a case, as if this were clerical rather than political. That language hides agency. It also obscures the internal pressure already visible in June 2025, when the court declined Snoop v. Brown, but Justice Clarence Thomas openly signaled that he wanted the ban reviewed. That dissent was not a procedural footnote. It was a statement of intent. The case did not emerge from uncertainty. It emerged from a court already split, already leaning, already looking for the right opening. Kavanaugh's tell. Brett Kavanaugh's earlier comment that a denial of certiorari does not mean the court agrees with the lower court was never a neutral explanation. In context, it read like a marker left in the road, not now, but soon. Vance's right to treat the new grant as a shift, not a surprise. If a justice publicly says the court should, and presumably will address the AR-15 issue soon, then the institution is not wrestling with whether to intervene. It is deciding when and with what cover. What this pattern reveals. This is how judicial power operates when it wants to look abstract while acting concretely. The court can refuse review, signal discontent, wait for the right time, then re-enter the field and claim it is only resolving doctrine. But doctrine is the costume, power is the engine. On guns, as on Trump-related shadow docket fights, the justices are not merely interpreting law. They are choosing the political terrain on which law will be enforced, narrowed, or broken open. The larger pattern. The real pattern here is institutional self-authority, a court that treats its own timing, discretion, and strategic silence as if they were impartiality. That is how elite institutions launder ideology into procedure. They do not announce the outcome first. They curate the appearance of inevitability, then present the result as jurisprudence. You've been listening to Systemic Error. Thanks to Raw Story for today's article, with the automated voice of Joe. Thanks for listening.